jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do just in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction in the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter-parties arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a civil, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter-parties, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever between the parties, but for the purposes of election will have a time frame?
My Lord,
such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter-parties arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
My Lord, that was a bit later, but may I address it right now? My Lord, when your Lordship looks at 62(1)(f), the constitution makers under the 18th Amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your Lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your Lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My Lord, may I just preface this a little further?
Sure.
My Lord, a question has been asked and repeatedly, and my Lord, Mr. Yahya Afridi asked that again yesterday. Why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My Lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30 years of age. And that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your Lordship looks at them, there is no disconnect. The qualifications are separate, the disqualifications are separate. Sorry, there is a disconnect. They deal with two different subjects. One where a qualification is acquired, one where a qualification is lost in a way, or a disqualification occurs because the person loses sanity, or the person loses citizenship, or a person becomes an undischarged insolvent. The moment the court declares that person as insolvent, then the disqualification is removed. Moment there's a declaration that the person is of sane mind, the disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The
साहब एक क्वेश्चन पहले भी पूछा है पर उसमें क्लैरिटी नहीं आ रही कि 62 आर्टिकल 62 applies pre-election, post-election or at any time.
My lord, the way I look at it, election 63 applies at any time.
Yes.
62 applies only at the time of election because he shall not be qualified to be elected or chosen as a member of Majlis-e-Shura
At the
Parliament.
time of filing nomination,
Yes, my lord.
and a person files his nomination and his opposer submits some document before the returning officer that something, yeah, decree has been passed against him, so he is not eligible to contest the election.
My lord, yes.
Is it your meaning?
My lord, my
By the
submission.
declaration of law, because opposer can file the application, his nomination form should not be accepted because he is not eligible to contest the election.
My lord, yes.
So what is the main interpretation of Article 62, whether it applies at every time, it applies before the election or any time after election?
My lord, 60, when your lordship looks at 62 and 63 and reads them together, because that's where I was coming to, after 1985,
And what is the difference between the opening language?
my lord, the opening...
Person shall not be qualified to be elected, and if you look to 63, a person shall be disqualified from being elected. So
My
there
lord,
must be some distinction between the
Yes.
framers of the Constitution.
my lord, may I...
If I may interject, Mr. Makhdoom Ali Khan, and it may help you to respond to my lord as well. Somehow, as I see it, we've got bogged down in restricting ourselves to reading just a particular provision of the Constitution. And we seem to have forgotten the Constitution as a whole. What is the Constitution all about? What does it do? What are the fundamental rights? Article 17, more importantly. And we are going to a particular provision of the Constitution and just reading those and disregarding everything else. We're disregarding the history of Pakistan. We're disregarding the constitutional history of Pakistan in particular. We're disregarding the fact why these amendments were brought into the Constitution. We're disregarding the fact that original Constitution has a greater sanctity than amendments brought there too, unless there are such amendments which enable to serve the people better. For instance, Article 19A, Article 10A. Now, nobody can say that these insertions have taken away something from the people of Pakistan.